Welcome to the foundational course on company law, a subject that forms the very bedrock of modern commerce and enterprise. At its core, company law is the body of rules, principles, and procedures that governs the life of a company, from its birth through its operations to its eventual dissolution. This legal framework makes it possible for individuals to pool their capital and skills to undertake commercial ventures with a level of protection and structure that would be impossible otherwise. Company law is not a peripheral subject but a central pillar of business strategy. Every major decision a company makes is framed, enabled, and constrained by the provisions of company law. Ignoring this legal context is, honestly, a bit like trying to play a complex game of chess without understanding the rules governing how each piece can move. The framework for corporate governance, the system of rules, practices, and processes by which a company is directed and controlled, is a core concern of company law. Strong corporate governance is no longer seen as a mere compliance burden. It is recognized globally as a hallmark of a well-managed, sustainable, and trustworthy enterprise. To master company law, it is essential to understand the ecosystem of statutes and regulatory bodies that create and enforce the rules. At the very center of this universe is the Companies Act, 2013. This comprehensive statute is the primary source of company law in the country. The primary administrative authority is the Ministry of Corporate Affairs, or MCA, which operates through the Registrar of Companies, or ROC, and the Specialized National Company Law Tribunal, or NCLT. For companies whose shares are traded on a stock exchange, an additional and powerful layer of regulation comes from the Securities and Exchange Board of India, or SEBI. A business leader must also be aware of how company law intersects with other critical legal domains like insolvency, foreign investment, and data protection. A company is an artificial legal person, a legal construct created and recognized by statute. It possesses a distinct identity separate from its members. The foundational doctrines of modern company law flow from the landmark 1896 House of Lords decision in Salomon v. A. Salomon & Co. Limited. This case decisively established that a company, once legally incorporated, is an entirely separate entity from its shareholders. This principle gives rise to three interconnected concepts: separate legal entity, often called the corporate veil; limited liability, which caps a member's financial risk; and corporate personality, the capacity to own assets and enter contracts in its own name. Companies are broadly categorized based on the number of members and the transferability of their shares. This gives rise to the most common distinction, that between a private company and a public company. A private company places restrictions on the right to transfer its shares, limits its members to 200, and is prohibited from making any invitation to the public to subscribe for its securities. In stark contrast, a public company can raise capital from the general public by issuing a prospectus and listing its shares on a stock exchange. The choice of entity form is a foundational strategic decision. It must be based on a careful analysis of capital needs, investor expectations, and the compliance burden the business is willing to undertake. Incorporation is the legal process that brings a company into existence. The key individuals are the promoters, who conceive the idea and undertake the formation. The modern incorporation process is streamlined through a single integrated web form, SPICE+. This form is a single-window application for multiple services. Proposed directors must obtain a Director Identification Number, or DIN, and all subscribers must have a Digital Signature Certificate, or DSC, for the electronic filing process. The process culminates in the issuance of a Certificate of Incorporation, or COI, which is conclusive evidence of the company's legal birth. Next, we will explore the constitutional documents of a company. The Memorandum of Association, or MOA, is the supreme constitutional document. It defines the company's scope of authority and its relationship with the outside world. Any act done by the company that falls outside the scope of its objects clause is considered ultra vires and is legally void and unenforceable. The Articles of Association, or AOA, are the internal regulations that govern the management of the company's affairs and the conduct of its business. This leads to the doctrine of indoor management, which protects outsiders by allowing them to assume that the company's internal procedures have been duly complied with. Capital is the lifeblood of a company. The Companies Act, 2013, provides a detailed framework for how companies can raise funds. A prospectus is any document inviting offers from the public for the subscription or purchase of any securities. Its purpose is to provide investors with all material information to make an informed decision. The Act imposes severe civil and criminal liability on the company and its directors for any untrue or misleading statements in the prospectus. Allotment is the formal acceptance by the company of an offer to purchase shares. A key condition is minimum subscription. The minimum amount stated in the prospectus must be subscribed before any allotment can be made. Share capital is primarily of two types. Equity shares represent true ownership with voting rights, while preference shares carry a preferential right to dividends and repayment of capital. The capital structure must be designed to align with the company's long-term goals, risk appetite, and control objectives. Corporate governance is the system of rules, practices, and processes by which a company is directed, controlled, and held to account. The law prescribes detailed requirements for the composition of the board to ensure a proper balance of skills, experience, and independence. The law explicitly codifies the duties of a director, who must act in good faith and exercise their duties with due and reasonable care, skill, and diligence. To manage its workload, boards delegate responsibilities to specialized committees. The most critical is the Audit Committee, which oversees financial reporting and internal controls. The Nomination and Remuneration Committee is responsible for identifying qualified directors and formulating the company's remuneration policy. The Companies Act also introduced mandatory provisions for corporate social responsibility, requiring large companies to spend at least 2% of their average net profits on specified CSR activities. Shareholders exercise their power primarily through general meetings. The most important is the annual general meeting, or AGM, which every company must hold once a year. Decisions are made by passing resolutions. An ordinary resolution requires a simple majority, while a special resolution requires a 75% majority for more significant matters. To ensure credibility, the law mandates an independent external audit. The auditor's report provides assurance to stakeholders that the financial statements present a true and fair view. Piercing the corporate veil is a judicial act of disregarding the separate legal personality of a company to impose liability directly on its members or directors. The law will not permit the corporate structure to be used as a cloak for fraud, to evade a legal duty, or when personal and company affairs are hopelessly mixed. The Act establishes a broad and severe provision for the offence of fraud under Section 447, attracting penalties of imprisonment and heavy fines. The Act also provides a detailed NCLT-supervised framework for corporate restructuring, such as mergers and amalgamations, to ensure the process is fair and transparent. Just as the Act provides for a company's birth, it also lays down the framework for its death or dissolution. This can occur through a formal winding up, where assets are liquidated to pay debts, or a simpler striking off for defunct companies with no significant assets or liabilities. The rise of the startup ecosystem has presented unique legal challenges, requiring a flexible and enabling framework. This ecosystem relies on specific legal instruments, like founders' agreements to define roles, term sheets to outline investment terms, and ESOPs to attract and retain talent. A deep understanding of company law is not a peripheral skill, but a core competency. The law is not a barrier. It's the very chessboard on which the game of business is played. The legal framework is one of the greatest enablers of economic activity, providing the stability, predictability, and trust necessary for markets to function effectively. By integrating legal intelligence into your strategic thinking, you transform compliance from a reactive cost into a proactive, value-adding component of your leadership toolkit. Use this knowledge not only to build successful enterprises, but to build businesses that are ethical, sustainable, and a force for good in society. We wish you the very best in your professional journey.